Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call every other Thursday. I have not had the chance to review our questions today. I was a little busy, and I have another call scheduled at 1:30, so we'll be calling the conference off at exactly 1:25. But I have enough time to answer the 21 posted questions, and I'm going to do my best to take all the follow-up questions as well. Let's begin with the first question. It is marrying a Canadian and bringing her to USA. So Chucky91, the poster, is in Texas. She's in Canada, not yet engaged, but soon. Before we get engaged, I want to have a plan on how this process works so we can navigate appropriately, see if we can. Okay, so basically the idea is she's a Canadian citizen. Ultimate goal is to bring her to USA to live with me. This is actually a question that comes up quite frequently. It is almost a frequently asked question, but I've discussed it several times before. What is really a bad idea is to bring somebody in on a tourist visa with the preconceived intention to convert it to a green card. Government can often take that as a fraudulent move. A Canadian citizen are a little different. They don't need a visa to enter USA, but still it's a bad move to have somebody enter USA on a tourist visa or even a Canadian type visitor visa or visitor status and then try to convert them to green card. It's a bad move. Okay. Most of these cases, if you're on H1, L1 type visa, there's no issue, because if your spouse, you are a US citizen, your spouse is on H1, L1, the world is your oyster. You can do whatever you want because they're already here, or they can be here very quickly. But if H1, L1, etc. or O1 are not an option, then in my view, a fiancé visa is the most straightforward thing. A fiancé visa, also called a K1 visa, is basically when you go through the process, you show to the government, file certain forms. What the forms are, you'll have to check. I don't know what the forms used are. I think it's 129 for fiancé visa, but don't quote me on that. So in the fiancé visa, what is important is you must have physically met, and you have, and you must get married within 90 days after she enters USA. But the time period of fiancé visa is so unpredictable. Is it going to take 3 months or 9 months or 10 months? We can't tell you. But I think that's the cleanest way. Bring her here on a fiancé visa. Because she's a Canadian, while the fiancé visa is pending, she can come and visit in the meantime. I don't think she's going to get stopped. But if it comes up, the issue comes up that you have a fiancé visa pending, they could turn her away at the border. Okay. So first step, in my view, would be K1 visa. Let's see what you are asking. I need assistance on what I need to do and what she needs to do. Actually, she doesn't do anything. Most of the work is done by you. You are the petitioner. You will file the forms. The forms will get approved. They will go through certain process, ultimately arrive at the consulate in Canada, where she'll be told to go get her medicals done and appear for an interview. And that's typically how the fiancé visa process works. All the work is yours to do. Where do we need to get marriage certificate? I think it's perfectly okay for you to get married in Canada. I don't like the idea of getting married in USA because I feel that even that becomes an issue if the government wants to. Normally they don't. That why did you arrive in USA? What were you doing here? And if you say at the border, at the airport, I'm coming to get married, they might turn you back. But if you say I'm coming to visit, that's really not the truth. So when you don't tell the truth, that becomes a big issue. Want to get married by January 2020. I think for you, K1 is the perfect option. You shouldn't get married at all, because K1 is for people who want to get married, but they are just engaged. Engaged doesn't mean you have to have any kind of a ring exchange or anything. It simply means people who are intending to get married. You asked me what is the difference between marriage license, marriage certificate. Marriage license is the permission to get married, and marriage certificate by the government, and that depends from state to state what the rules are. and marriage certificate is what you get after you get married. But really what you want to do is look very carefully into fiancé visa. Okay. Any follow-up questions on this, Chuck, or anybody? Press *5 on your phone. *5 if you have a follow-up question. Okay. Let's go on to the next question. From Anani2019. I'm a new US citizen, fiancé in India. She's a widow with a child. Tourist visa plans to visit USA for 15 days during Christmas with her kid. If we choose to move forward with the decision of getting married, what is the best route going forward? Again, I just answered that question. I think you should start her K1 visa process. And I don't think getting married in USA is generally a good idea. Look, if somebody enters USA with a tourist visa, I had a case like that just a few months ago. Somebody, and this is a typical case where it's okay to do this. Somebody came from India. She was a scientist. She was sent by her company to attend a conference. She gets here. While she was in USA, before that, she had this gentleman she had been dating, a US citizen. And they were close, but then she left to go to India for some family reasons. And she'd been gone a few years. The intention was just to come here, attend the conference, and go back. Interestingly, he came by to see her during the conference time, and they started talking. Next thing is he proposed to her, and she said yes. So when they called us, I looked at the circumstances. She had a return ticket. She had no intention to get married. All her belongings were in a small bag, good for only about a week. In fact, even her wedding dress and everything had to be flown in from India. And that's what we intended to prove if we were asked. But that case went through smoothly without any questions asked. So what happens is if you enter and then you change your intention, that's okay. But if you have a preconceived intention to get married or to try to convert to green card, I think things become very tricky. So avoid that situation. I would say K1 visa. But for K1 visa, you must not be married. Okay. *5 if you have a follow-up question on this. *5. Yeah. So for you, Anani2019, I would say K1 visa. Let her leave and then do a K1 visa. Next question is Oh, this name is difficult for me to read. Bharani Thangavelu. Okay. Bharani says, this is a long fact pattern. Let me see what I can do with it. And I apologize, guys. Normally, I read the questions at least once before I log in. But today, I had absolutely no time. So, I'm reading them as we go along. It's a little slow going maybe, but I'm doing as best as I can. Indian citizen, J1 visa, spouse is on J2. Previously on F1, PhD in chemistry. Postdoc researcher, 1 year, Cleveland Clinic. Okay. US Army, job offered at the Material Research Command. Walter Reed, Army Institute of Research through National Academy of Sciences, sponsored the fellowship. That's pretty cool. This is a highly competitive international-wide fellowship. The only downside of this offer was to switch to J1. Okay. So the offer was too good to turn down. I got my J1 visa, took this position. I'm working there at the Department of Defense funded project. I'm a lead researcher working on several key projects which are directly linked to help US Army troops in traumatic brain injury. I'm a trained biochemist with hardcore training in advanced bioanalytical instrumentation, including HPLC and mass spectrometers. Okay. By the way, guys, my first degree is in biology and chemistry. So I'm a science geek myself. I always wanted to be a lawyer. That's why I went into this. But my first degree was also in bio and chemistry. I loved the sciences. Wife got EAD, J2 EAD, currently working as HR manager in healthcare firm. Okay. So my goal is to apply for NIW through EB2. I've already obtained no objection to return for J1 waiver. Okay. All right. Though I work for the US Army, I don't think they're open to sponsor me on an NIW. Okay. So first of all, you realize that NIW is just a category under EB2. So the green card will take as much time as anybody who's under EB2 category. As far as chances of filing for an NIW, there are two roads to NIW. there is one road which talks about request from an interested government agency. As I recall, Department of the Army used to have a department. I think it was within, I want to say, Under Secretary of Defense. Is that the official title? But it was an office within the Department of the Army that did recommendations for things like J1 waivers and for national interest waivers. So they used to write a letter that would say, because at the request of an interested government agency, you can get a waiver, a national interest waiver, which leads to a green card. It has to be a federal government agency. And the second road is to show to the government that your work has intrinsic merit, which is good for the USA, and you are ideally suited for that position. It's not ideally, but you're well suited. And 3, there is interest. And I think you could do an NIW. You can send me your resume. We can talk offline. I looked at your citation history and all. I'm just looking at it now. I think there's a possibility, Dr. Thangavelu. Just go ahead and send me your resume at help@immigration.com. We don't charge for resume reviews. Help@immigration.com. Okay. *5 if anybody has a follow-up question on this, guys. *5. Okay. I'm trying to zip through all 21 of my questions so that I'm at least able to finish today's task. Amin 163. My H4EAD, wife's H4EAD, good till July 2019. H1B transferred H1B transferred to employer B, good till December 2018. So your H1 is less than her H4. That's odd. Okay. Will my wife be able to work after December 2018? This is such a difficult question to answer. Because in one way, she's got the EAD. Why shouldn't she? On the other, if you look at the theoretical underpinning of why she has an H4, it is completely coextensive with your H1. So my practical suggestion, if you want to be a little aggressive, I would say, yeah, go ahead. If you want to be conservative, don't work after December 2018 until the new EAD comes. But the midway approach is also to call USCIS customer service, ask to speak with an adjudications officer, not the frontline staff, and make a note of the name of the officer and the advice they give you, the date and the time. If they tell you she can continue working, by all means go ahead. The adjudications officer probably wouldn't know the answer, because if I don't, they also don't. But they may have a policy or a nod and a wink internally that might be able to give you better guidance than I can. Okay. Planning to move to Canada as the green card wait time is extensive, become a Canadian citizen. Oh, no. You don't come under the rest of the world. Your green card chargeable country is based upon your country of birth. So if you were born in India, but you become a citizen of Canada, that does not make you chargeable to Canada. You will still be under the India quota. Okay. *5 if you have a follow-up question. *5. Okay, let's keep going then. I just want to make sure I'm not missing anybody's questions. Nope, there are no questions. Okay, so Venkat says, I'm working on EVC model, which I guess end client, vendor client, something like that. Employer vendor client model. Okay. In H1B visa since last 4 years, first H1B did in Mumbai with the same employer. Changed multiple clients in past 4 years with multiple H1B amendments and extensions. I-140 approved. Planning to go for second stamping in Mumbai to visit home. Few days back, you were stuck in Tijuana entry point. Okay, this is a complicated fact pattern. What happened with you was you went to Tijuana. You went to make a U-turn via Tijuana. Oh, wait. While driving in San Diego, thought to visit border side area and got stuck in Tijuana. So basically you went to Mexico and came back, and you didn't have a passport and a visa. You just had your driver's license, and they let you enter with a waiver, I-193. Sir, I don't know exactly what I-193 does, but the fact that they let you in tells me that you have entered legally and it shouldn't be a problem. Just do one thing, double check your I-94. It doesn't look like they did anything with the I-94 processing, and it does look like they let you enter on AVR. That's what it looks like, because the waiver was granted because you didn't have the passport and the visa. But really your right to return was based upon the fact that you had an AVR, automatic visa revalidation. Or you have verified, okay, good. You already verified I-94 number was not changed. I think this is fine. And adding Mexico is fine too. I don't think it's going to be any problem for your H-1B stamping. If they ask you anything about it, you tell the truth. Oh, AVR is a well-known process, so you shouldn't have any problem. Even the consulates would understand that. Now, I've not seen this situation before, but the legal operation of the various factors that govern your entry into the US is the same as anybody else's. I don't see anything extraordinary here. I would have to look at the Form I-193 and its implications. Have your lawyers look at that? But it doesn't look to me like it's a major issue for any kind. Star 5, if you have a follow-up question, folks. Star 5. Okay. So, Tori Lore, I don't know how to say this, sorry. F1 visa, finishing my degree, OPT was denied because of some problem with the DSO. Filed for an asylum. You have to forgive me, I don't know anything about asylum laws. Okay. So you were technically unlawfully present for 30 days between OPT and asylum application. Okay, now I really don't know off the top of my head whether filing for an asylum tolls your unlawful presence or not. If it does toll your unlawful presence, then you have the benefit of 245K. Okay, so that's the real question. If filing for asylum tolls or stops the running of unlawful presence, there is no problem. But if it does not, then you are subject to the 10-year bar. You will need waivers. Okay. Star 5, if you have a follow-up question. Star 5. Krishna says, my H-1B extension applied April 26th. Transfer to Nebraska, RFE received. Employer is working on RFE, 240 days will be completed. Can my employer upgrade to premium? They can, but right now premium is not available. Unless yours was an extension without change. You don't have to leave the USA, you just can't work after the 240 days. And if you were to leave the USA, you would just have to get, your H-1B would be approved and you would have to get a visa before you can come back in. That's all. Star 5, if you have a follow-up questions. Krishna, if you have a follow-up question. Okay. Irfan had, I guess, 2 questions. So let's go. A couple of questions related with H-4EAD and starting a business. My wife, who's on H-4EAD, wants to start a business. What kind of company should I open? C Corp, LLC. No, I'm not the right person for this. Remember, corporate law is a state law issue. It is not federal immigration law, which we can give you advice from any state. So you need to contact a local professional. For smaller companies, I think going to a CPA is okay because they can help you set up the accounts, the tax structure, whatever you need to do, and they can also help you incorporate. We used to use a company, there are a lot of incorporators online. Just find a reputable incorporator, $400-500, they should be able to incorporate a company. But you can also check with your CPA. What will happen if H-4EAD is revoked? You can't work anymore. So she will not be able to work anymore. That's what would happen. Star 5 if you have a follow-up question. Star 5. Let me just make sure you guys can hear me.
The conference is now in conversation mode.
You guys can all hear me, okay? Right?
Yes.
Yeah?
Yes, Rajiv.
Oh, okay.
Yes.
Okay.
Yes.
I worry sometimes. I have done conferences where
The conference is now in presentation mode.
People couldn't hear me and I just kept talking. So, okay. So this call, yeah, we are fine here. Call is being recorded. Okay, good. Next question is from Kumar 452007. I'm on H-1B visa, I-140 approved, EB2 priority date 2016. Working as a DBA. I want to move to BI domain, which is business intelligence, I guess. If I switch to new employer with new job title, new job description, you do need to process your perm again, even if you remained a DBA, sir. Because you can't carry forward your I-140. You can carry forward your 485 if that has been filed. Otherwise, every time you change jobs, you will only be able to carry the priority date of the first approved I-140. Okay. You can't carry anything else. And it should not affect your existing I-140 and next H-1B extension. You see, if your I-140 is approved for 180 days and stays approved, your right to keep extending your H-1 remains intact even if the old employer revokes the I-140. That's the good thing with the new regulations. They can use your existing employer's I-140 to file the next extension. So if you were with employer A who got the I-140 approved, employer B, C, D, E, F, anybody can file an H-1B extension based upon approval of the employer A. No problem. My current company A is acquired by another company. And my I-140 was sponsored by A. Can company B take over? Of course. Of course. And once the I-140 is approved, you have nothing to worry about your priority date and the right to extend your H-1. But if you want the green card to continue with company A, and they are successor in interest, there are certain legal requirements, I don't see any problem with it. But you would have to refile the I-140 though. If I switch company now, will company A approve I-140 get extension? Once the I-140 is approved, even if the company A gets taken over, you can still keep getting extensions. I don't see any problem with that. Yeah, I don't see any problem with that. The fact that company A got taken over does not in any way interfere with the already approved I-140. Okay. Star 5 if you have a follow-up question. Star 5. Okay. Let's go to Lebu. I got a green card through my husband on April 2010. Working in my home country till August 2016. Traveling back and forth once a year. Finally moved to USA permanently on December 2016. Became eligible for citizenship, applied for naturalization. Oh, that's not a good scene. Husband had filed taxes jointly showing me as a dependent. Yeah, see, if this is fraud, if he was just claiming you as a dependent and you were not, I see a couple of problems right off the bat with your case. You should get together with a local lawyer, discuss your case in detail. Instead of getting naturalization, you could end up losing your green card. Because first of all, it sounds, from a common sense perspective, not being judgmental, just being commonsensical, it sounds odd that a husband and wife are living apart and meeting only once a year. Secondly, he's claiming you as a dependent. If you're not a dependent, I don't know what the tax requirements are, not a tax lawyer. Talk with a tax lawyer or a CPA. I think you should talk to definitely a local lawyer wherever you are. That naturalization could cause you problems. You could actually end up having your green card in trouble. Okay. Star 5 if you have a follow-up question. Star 5. All right, no questions. Wow. Jay Desai in USA since August 2001, came on student visa, 2 masters, 1 in finance, other in insurance, working for the same employer for last 12 years. Priority date is 2010, EB2. Now he's got an extension RFE on specialty occupation. I need your help in replying. Mr. Desai, we are not taking cases because we are so busy with our existing clients. We are only taking cases where the company is moving their entire immigration business to us. So if a company calls us and says, we just want you to do one case, we won't do that. But if a company says we want to eventually move our entire work over to you, we'll be happy to assist, because then we are building a relationship. Individual cases we don't have time for. But if you want consultation, just my guidance, I can try doing the best I can. You can send me an email to help@immigration.com. RFEs are routine, but they are never to be treated lightly. They should be attended to very, very carefully. Remember, the government estimates are that their denial rates have gone up 40%. Now remember, this is 40% across all H1s, including them some really strong H1s like doctors, physicians H1s, or scientists H1s, dentists H1s. I think if you isolate the technology industry, the rate of denial may be much higher, maybe 60, 70%. That's my guess. So you've got to be careful. Approach this very carefully, okay? Star 5 if you have a follow-up question. Okay. Let's see, New York. Go ahead, New York.
Hello?
Yes, sir, I can hear you.
Yeah, see, my question to you, for last 4 times, they never raise anything.
Oh,
And fifth time,
Mr. Desai, let me stop you there for a second. Government does not consider itself bound by earlier rulings. Every time you file an extension, an amendment, or transfer, it's a new case.
Okay.
Okay. So
Okay.
I'm assuming that you're working as an accountant.
No, I am working as an operation research analyst. It's something like a finance job.
Oh, I know what operational research analyst is. The thing is, if you are truly an operational research analyst, you have to just establish that it requires a degree in a specific field. And that's typically what they're asking. It's never easy. It's always a lot of work, but take it seriously, but don't think this is the end of the world. All right?
Okay, but if I need your help in drafting that reply.
We don't take individual cases, Mr. Desai. We stopped doing that early this year because we just couldn't keep up with all the demand. So we are only doing cases for sole source companies where we are the only immigration lawyers they use.
But you said you can somebody
I can
in your
advise
company
you. If you have any specific questions,
yes.
I can certainly find time for me to talk with you. But the firm can't be committed. Our team is very busy.
But, because that's the problem. Because my earlier attorney, I don't know whether they are good in drafting this reply. I just need your help only in just checking that whether this, or you can make some suggestions or editing or something like that.
I want you to do something. Do this. Actually, this is good for all of you guys who are listening. In the Google or any search engine search bar, Google I know goes directly to what I'm saying. Type the word AAO. That stands for Administrative Appeals Office. Type AAO space decisions. Why am I sending you there? It gives you a good idea of what the government is thinking. So when you go to that page, that is the Administrative Appeals Office of USCIS. And what you can do is, there is an internal search page within that page. You can type in that, in quotes, specialty occupation, space, or I think you can use and then whatever your field is. So you can say, in quotes, operations analyst. What you might find is a bunch of cases where they have decided for or against people who filed as operations analyst. I think that gives you a very good idea of what the government is thinking. So go to AAO decisions, go to the search box within that, in quotes, type specialty occupation, and, so word and, whatever your field is, and put it in quotes. You can put operations analyst. So people who write SQL queries, they know exactly how this works. So it's basically a high version of SQL or search query. When you see the cases, just read the first cases, the 2018 cases, 4 or 5 cases. They'll give you a good idea of what is involved. Okay?
Okay. And is it necessary that my deadline is February 10, 2019. Is it okay, no, even if I reply after doing all those research somewhere in the first week of February, that will be fine, no?
As long as you get your papers to the government before the deadline, you are okay.
Okay, sir.
All right.
Okay.
Good
Okay.
luck, sir.
Thank you.
Good luck.
Thank you.
Good
Thank
luck.
you.
Bye-bye.
Thank you.
Okay, so guys, the problem is H1 RFE responses have become very, very big deal. Our average last response I looked at was, the minimum I have seen is about 150 pages, and some of the responses go to 600 pages because we have to get so much evidence, put it all together. So we decided that we can't really do it for individual people. If we have the company, okay, today we are helping them in respond to an RFE. Tomorrow we can set up their whole infrastructure according to our method, so that their chances according to our experience are much better. So instead of trying to patch cases, if we can take over the infrastructure, that works much better. And we work with companies as small as 1 employee company to, I think our largest employer is about 150,000 employees. So, okay, going on. Santosh. My name is Santosh. I came to USA in 2008, F1 status, earned a master's degree in 2009. H1B got approved, transferred to company B, everything extending great, then moved to a different client, applied for amendment. Now I got a notice of intent to deny, saying that my client is a for-profit organization. These cases are difficult to win, sir. I think you should definitely apply in April again, because if indeed they approved your case mistakenly under the master's degree quota, they can deny it. We have dealt with some of these cases. I'm not sure we have won any. I don't remember off the top of my head. But as far as the law is concerned, I think the law is against you, because the letter of the law says that the university must be of a certain kind, must be a non-profit or a state university, etc., etc. And if it doesn't match those requirements, then they can indeed revoke the H1. And I don't know what arguments we have taken. I think in the beginning we won a couple of cases. After that, we decided that this was becoming very difficult. I don't know off the top of my head. If you want us to set you up for a consultation, we can. I can take a look at some of our cases. You can send an email to help@immigration.com. I will be happy to set you up for a consultation. Okay. *5 if you have a follow-up question. *5. Okay. Let's see. We have one. And this is from Virginia. Yeah, Virginia, go ahead, please.
Can you hear me, Rajiv?
I can. Yes, sir.
Okay. So, I mean, what you said, I'm okay with your statements. And one question that I had is, can I stay here and apply for H1B in regular quota with my bachelor's degree?
Why not? But the only thing is, if the notice of intent to deny is actually acted upon, from that day forward, you're unlawfully present. Okay. So, as long as the notice of intent to deny is not acted upon, they don't actually deny your case, you are legal to stay. But the moment it is denied, you have to leave because you will be unlawfully present.
Okay. The other thing is, I know it's just a statement of support for my case, and my OPT extension was till April 2012, and my H1B visa got approved in 2011. So I think I had enough chances to stay with my OPT till 2012 and file H1B under regular quota. Who knows what could have happened.
Yeah, but the thing is, hang on. Unfortunately, the government is not tied to its mistakes, no matter how much you suffer. That's the way the courts look at it.
Okay. So there is every possibility that I could apply for a regular H1B.
Definitely, you must.
Because I have a 140. Okay.
Yes.
Okay.
You must. Okay. Good luck.
Thank you. So can I stay with my same employer and file for H1B in a regular quota?
Why not? Why not?
Okay. Because I heard it's not possible, so I just wanted to check my case.
That is incorrect. You can.
Okay.
Good luck, sir.
Thank you.
Okay, let's go on to the next one. Guys, I'm not going to have time for new questions. I have to leave at 1:25, which is 20 minutes from now. I'm going to be able to finish the questions we have, but not beyond that. Swami says, I'm on H-1B valid through March 2020, stamped on my passport. Employer is a US-based consulting firm working as a contractor at my client location. Currently in India, I found that my client has terminated my contract. You shouldn't come back. No, I think that would be a problem. Stay in India. You should have your employer file for a transfer or, an amendment if they have another contract for you. Until that is done, you shouldn't come back. I think you can still use the same visa. So if they get you a new H-1B, I think you can use the same visa to come back. Even though the consulates have said no, I think their standard operating procedures say that you can. So you can have your lawyers double check that, but get your H-1B amended. And that's probably going to take several months simply because there's no premium processing until February when they might reinstate it. Okay. Star 5 if you have a follow-up question. So no, don't come into USA. I think that would be a bad idea. Okay. Next one is Hasmukh. I'm on H-1B, same employer, past 10 years, green card filed, EB3 I-140 approved, then EB3 to EB2, got EB2 I-140 approval. Can I file my 485 based on the EB3 approval? The answer is that depends. There are several factors which I look at. I look at what are the two job descriptions. How far apart are they? Is it reasonable to say that you'll be able to take the EB3 job? So this is not a question I can answer in vacuum. You should definitely talk to your lawyers, have them make an assessment. Normally when we do it, we've done a bunch of these cases, we are quite confident that both under EB3 and the EB2 the job survives. So have your lawyers look at your casework, please. Do you need anything specific from the employer? Not really. It is really at this time a legal call. Once the lawyers look at the two job descriptions, they can then talk with your employer and ascertain that both jobs are available. If not, you can only have the EB3 job available. It's really not required that you must have both jobs available. But whatever you are filing under, if you're filing under EB3, that job should be available by the time you get your green card, and you should intend to take it. It's a little complicated for me to explain, but talk with your lawyers, and the answer is theoretically you can. You can file EB3 based 485 even though you have EB2 approved. Okay. Star 5 if you have a follow-up question. Star 5. All right. Let's go on to question number 6. Oh, there is a... Guys, be a little quicker about pressing the button. Let's see. Which one is this? This is... oh, I can't... It's the area code 312. Area code 312 is Illinois. Okay. Let's get Illinois. Yeah, Illinois, go ahead.
Hey Rajiv.
Hello, sir.
This is regarding my regarding the previous question. This is Swami. Sorry, I was too late to hit that button.
No worries. So coming to USA on H-1B after the project.
They have actually.
Yeah, I got that.
They have actually extended my contract till December 31st. Is it okay to enter into US before 31st, or how does it work?
I am very reluctant to have you come back simply because it's a little too aggressive to come back for a 2-week project. Are you going to come and work for 2 weeks on the project?
Yeah, I can still come back and work right from US.
I think they should just file an H-1B amendment. I think this is a difficult situation. The extension is too short. On one hand, I think legally you are okay, but on the other hand, if government wants to make it a problem for you, saying that you really didn't have a project, you just had an extension for 2 weeks, you shouldn't have entered. I don't know what is a good way to go here. Difficult decision. The conservative approach is to not come, until an amendment is approved or transfer is approved. The aggressive approach is, hey, I got 2 weeks, I'm going to come back and work. In that time, my employer can file an amendment. I think I can't find fault with that either. Okay?
Okay. Thank you, sir.
Yeah, good luck. I'm sorry, guys. I'm a little pressed for time.
Yeah.
I've got only about 10 minutes more.
Okay.
Yeah, good luck. Good luck.
No problem.
Okay, we got one more from 570. Yeah, 570. Go ahead, please. Area code 570.
Hi, Rajiv. Good afternoon. This is the same coming back to US after project finished.
Right. Go ahead.
You said like even if I have the visa valid, and then if I'm in India and the same time my employer has terminated, and they say like I have another H1 valid papers with me, you said I can come to US, right, in that situation?
I didn't understand that question, sir.
Okay, say like I have a valid visa and I am in India and my employer has terminated my contract.
Okay.
At the same time, I have another H1 papers, like a valid H1. In that situation, I think you said I can come to US.
The answer is yes, as long as that project for the second. Do you have another employer who filed an H1 for you?
Yes.
And they never revoked that?
No.
I think you can use that. Yes, sir. I do believe so. This
Okay.
becomes a little tricky. I do want you to hang on. I do want you to talk to your lawyers.
Sure.
Make sure it's okay, because I'm giving you a very generic general statement. Theoretically, it should be okay. Practically, is it or is it not? I don't know. There's only one dark area in this. When you got the visa stamping done, you were talking about a project with another employer. So by itself, that's not an issue. But I just want you to be aware of that and discuss it with your lawyers. I can't make that decision for you. Okay?
Okay, so say like I have my valid visa.
Yeah, I gotta go.
And then
I gotta go.
Okay.
Okay. But yeah, that
All
visa
right,
can
okay,
be
thank
used. That visa can be used for any employer, but again, not without talking with your lawyers. Make sure you do that. Okay. All right, guys. I'm not gonna have. I've got about 10 minutes more. Yeah, 10-12 minutes. Let's see how many I can get done. Arun says I'm filing DS 160 for my H1B stamping in India. Checked my LCA, employer filled it with client address only. Yeah, your place of employment is your actual, wherever you sit. Where do you intend to work? Give your end client address. Yeah, I believe the answer is, in a situation like this, we don't help fill forms, but generally speaking, I don't want to even look at the question on the form. All I can tell you is that your place of employment is where you actually physically sit. Your employer's name and address is your employer's name and address, but your place of employment is where you actually go down and sit on the chair. So if that's the end client, then put that. *5 if you have a follow-up question. *5. Aruna says, I've been pursuing my master's on L2, two semesters done, and received an 214B for an F1 visa. My husband's status has changed to H1. You can try for F1 visa stamping again. You won't get it probably, because 214B simply means they think you have immigrant intent and you won't come back. Part of the reason is because your husband is in USA. You can try again. As long as you don't misrepresent your facts, you can always come back on H4. And there is no impact of 214B denial. And they should not cancel your H4 visa. Okay. *5 if you have follow-up questions. *5. Okay. Adapa. Had employment-based EB2 green card interview in December 7th. Went on for about an hour. They always ask about your previous companies these days. Geographical locations, printed my answer, took my signature along with the witness, someone from USCIS signed. Okay. Your case is being held for review. Okay. One thing is, most of the interview was focused on a company which was blacklisted. I didn't get paid for 4 or 5 months when I was on bench. My attorney did not list this experience. It is difficult for me to give you advice in general, Sri, because if a company is blacklisted and their experience was not documented or written down in the paperwork, how material that is difficult for me to predict. All I can tell you is this is not an unusual situation. I actually have gone for a couple of interviews. Imagine in the last 30 years before Trump came into power, 28 years before that, I had gone to maybe 4 or 5 interviews at USCIS, only in very complex cases, because you don't really need a lawyer for these interviews. But in the past 6 months, I have gone for 4 or 5 interviews because they are making things so difficult in some cases. Most cases are still routine. They are going through. One of the cases, there was a company was convicted and they were trying to bring the employee into it. Employee had nothing to do with it. And interestingly, we had actually represented the company also. So I got permission from them to get some of the paperwork from their files. So the point is, it is definitely a lot more complicated now. And it's difficult for me to give you an answer in vacuum. I don't know what to tell you. We can review your paperwork and review your case if you want. Probably take me an hour, hour and a half to do that. But if you already have a lawyer, I'm not sure what else I can do if the lawyer is competent. Okay. Star 5 if you have a follow-up question. I would say sit and wait and see what happens. The only thing you can do in the background, if you want to, just get an H1B also in hand. Star 5, no question. Okay. Raj has a question. Oh yeah, there is a question. Area code 720. I guess that is Colorado. Okay, 720, go ahead, please. Colorado, go ahead, please. Hello, you had your hand up. Go ahead. Oh.
Hello.
Yes, ma'am, I can hear you.
I'm sorry, I was on mute.
No, that's okay.
Yeah, this is the new scenario. I failed to press star 5 earlier, so I tried now. And the thing is, my H1B got selected.
I am very sorry, ma'am. I don't have time for a
and
new question. Hang on one second. I don't have a time for a new question. I already said that in the beginning. But stay on the phone. If I do get extra 5 or 10 minutes, I'll call for new questions, and you called very early, so you'll be on top of my list. So stand by. If I have time, I'll call.
Thank you.
Okay.
Sure.
Leave your hand up, okay?
Yeah.
In fact, I'm leaving you unmuted. Just mute your phone.
Sure.
Okay. Raj says, I'm a green card holder, verge of getting married. She was planned to. I talked about this, Raj, in the beginning. Can she just go ahead and get the US visitor? We can get married here. Look, unless you disclose it that she's coming to get married, I think it's a bad idea. They may not give her the tourist visa if she discloses. If she doesn't disclose and she has the plans to get married here, they can raise an objection. Although, if you look at the Foreign Affairs Manual, coming to get married is not an impermissible purpose. So, all in all, I would rather have you marry in a third country. In the beginning of this discussion, I talked about a K1 visa. Now, a K1 visa may not be possible for traditional Indian families, because if they don't want to send their daughter without a marriage, that is understandable. Then you should just go through the green card process. And if it takes time, it takes time. Don't fool around with this process. I have seen too many cases get into trouble. A lot get through okay. People just, come here with a preconceived intention. They get married. They don't get questioned. I just don't like that idea, because I see the other side of those cases. So my advice would be either do a K1 through engagement and listen to the beginning of this conversation today. I have discussed this in length. And if not, then just get married in India and start her green card process. 1 second. Do you have any follow-up questions? Star 5 if you have a follow-up question. Okay. And the last question, it looks like I might have 4 or 5 minutes to do one more question. Arpit says my H1 was denied. I want to know how much time do I have left in my current H-1B, 6 years. So my H-1B was denied in March 2018. Last stamp visa. I can't tell this calculation. Oh, there is another question after that. I may not have time, guys. Sorry. There are more questions actually. One more question. If you're on the phone, press *5. I can't understand your facts. When was your H-1B approved? Press *5 because we need to know when was your H-1B approved? When did you enter USA? How many days were you outside? You can reclaim that time even if you're outside for 10 days during your H-1B period. So I really don't know what your question is. You may want to post a more detailed statement about your facts. And you're not here, so I can't really talk to you. Let's go on to the next question. Oh, there is actually 2 more questions. Ma'am, I'm sorry, I won't have time to answer your question, okay? Next time, just post it. I answer all the posted questions. I-140 was approved. This is Mira 99. I-140 was approved on 19th November. Companies laying off some of us. They will not revoke my I-140 next 7 months. Good. I have I-94. I-140, I-180 rule will work if I'm not on company payroll? Yes. It's not required for the 180-day protection that you should be employed with the company. That is not required. Can my company revoke after 140? Yes. After 180 days? Yes, they can. You cannot require, you don't really need anything other than experience letter from them. You cannot stay more than 60 days looking for another job. 60 days or I-94 duration, whichever is shorter. Okay. So if your I-94 is expiring in 35 days, you got to leave in 35. If I-94 is expiring in 90 days or 1 year, you can stay 60 days. And the premium processing is expected to begin in February. *5 if you have follow-up questions. *5. Oh, I skipped a question. Here is a question. Immigration 1982. Applied for EB2, got it approved. Company filed EB1C, got approved. Priority date was not ported. That's not a problem. Okay, supervisor is reviewing the file, will respond in 90 days. I don't know. They could be looking at the previous approval. I can't tell. As per my non-immigrant status, I'm on H-1B. Company tried my change of status to L-1A, which was denied after my EB-1C I-140 was approved. Can the service request be related to recent denial? It can be, because if the, remember L-1A and EB-1C is based upon the same grounds. If the L-1A is denied, then they might come after the green card and try to revoke that. I actually have a case like that. What happened was that gentleman's EB-1C was approved, but his L-1A extension got an extensive RFE. So the employer said, let's just walk away from it. And I just told them, no, because if we walk away from it, they could say, oh, that means this EB-1C is also questionable. They could go and reopen that green card. Although that gentleman is being interviewed like within the next couple of weeks, I will still respond to the RFE if I don't have a decision from the government before the RFE due date. So you should respond to every RFE in L1. It can become a problem, but I don't really know what the issue is. So all I'm doing is making a guess here. I think it could be anything, including this issue that you brought up. *5 if you have a follow-up question. *5. Okay. And this will be the last one because I have to leave in 2 minutes. Area code 720, go ahead, please.
My H-1B got selected into a 2018 lottery, and I changed the client. And after I changed the client, I got an RFE for the application. Now my question is, can I respond to RFE with new LCA, or how exactly should I approach for the case?
This is a tough question to answer. So your situation is, your case was filed, an H-1B was filed under the quota. It got selected. While the case was pending, you filed another H-1B amendment, right? Or transfer, right?
Not exactly, but for the same
Hang on.
application,
But
they sent out a
did you change employers on your
client.
hang on. Did you change,
I didn't.
ma'am? Can let me finish my thought, please.
I'm sorry.
Did you
Sure.
change because you were an OPT? Is that how you changed?
Yes, but again, I didn't change the employer, but the client has been changed.
Okay. So what you're asking me is really not, you haven't transferred employers, you have just changed locations, right?
Yes.
Okay. So what you should do is, you should respond to the RFE and at the same time file an H-1B amendment even while the first case is pending.
Okay.
That's what you should do. Okay.
All right.
Good luck.
Thank you so much for answering.
Oh, you're welcome. We do this all the time, so this is not something unheard of. Don't worry about it. Okay, folks, I don't have time to answer any more questions today. I'm a little short of time. I have a call scheduled in 5 minutes. Got to run. I'll see you again in 2 weeks. Thank you so much for being here. I love talking to you guys. Bye-bye.
Thanks. Bye.
Bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.